Good afternoon, everybody. Welcome to the panel of the Right to Abortion After Whole Woman's Health beat Hellerstedt. My name is Wenbo Zhang, and I'm the Vice President and Treasurer of ACS. And Nicole Scully, the President of If One How, and I are the organizers of this event. We have three distinguished panelists today with us. First, let's welcome Tara Romano, the Executive Director of NARAL Pro-Choice North Carolina. As a longtime advocate for women's equality, Tara Romano became a community activist for victims of domestic and sexual violence in 2003. In 2006, she joined NC Women United's Wake County Women's Agenda Assembly. She joined the NC Women United Board in 2008 and was elected president of the organization in 2013. In spring 2016, she joined NARAL Pro-Choice North Carolina. Tara currently serves on the steering committee of NC Women Matter and the Community Advisory Board for the NCSU Women's Center and the Women and Gender Studies program. She recently served on the advisory committee for the Institute of Women's Research Policy's most recent report, The Status of Women in the South. Next, we'll have Professor Neil Siegel. Professor Siegel is a David W. Eichel Professor of Law and Professor of Political Science at Duke Law School. He also serves as co-director of the program in public law and director of the DC Summer Institute on Law and Policy. Professor Siegel's research and teaching fall in the areas of U.S. constitutional law, constitutional theory, and federal courts. Professor Siegel will be moderating today. And lastly, let's welcome Professor Katharine Bartlett. Professor Bartlett is the A. Kenneth Pye Professor of Law. She served as Dean of Duke Law School from 2000 to 2007. She teaches family law, employment discrimination law, gender and law, and contracts. And she publishes widely in the fields of family law, gender theory, employment law, theories of social change, and legal education. She has a leading casebook with Deborah Road in the area of gender law. Now let's enjoy this panel.
Well, thank you very much, Wenbo, and thanks to the sponsors of this event and all of you for being here, and thanks especially to you, Tara, for being here and sharing with us your expertise as well as knowledge of facts and law on the ground in North Carolina. And if you don't mind, maybe we'll start with you.
Well, thank you, and thank you for having me. My name's Tara Romano. I'm with NARAL Pro-Choice North Carolina, and what I wanted to start with for this panel was just give you some history of abortion law and access here in North Carolina. I will say North Carolina, when I moved here in '99 and started actually working with NARAL, volunteering with NARAL in 2006, we talked about how North Carolina was really one of the more progressive southern states when it came to reproductive rights. That changed really quickly in 2010, but I do want to just give a little bit of background. Roe versus Wade was 1973, which legalized abortion in the United States. Prior to that, 1967, North Carolina was one of the states that did have some legal abortion, in cases of fetal abnormalities, rape, and incest, or, if the pregnancy was going to impact the health or the life of the woman. So abortion was legal in North Carolina starting in 1967. And then in 1978, which was 1 year after the Hyde Amendment was established, which is what banned federal funding, particularly Medicaid, but it has expanded to a lot of other federal funding, banned that federal funding for abortion. And so in 1978, North Carolina established a state abortion fund, which was really, actually, North Carolina was one of only, I think, 5 or 7 states that had a state abortion fund. And we had one of those up until very recently, which definitely was a pretty progressive thing for a state to have. And then in 1995, there started to be a little bit of the erosion of those rights. In 1995, North Carolina General Assembly required parental consent for minors who wanted to get an abortion. This is, one parent has to consent. There is a way for judicial bypass, which is difficult if you can't get a parent to consent or you're not going to ask a parent to consent. I do want to point out that this is for abortions only. A 15-year-old can decide to carry a pregnancy to term, and no parent needs to consent to that. So it really is a pretty ideologically driven piece of legislation. And that is a pretty common piece of legislation around the country, one that lots of people think, well, maybe that sounds kind of reasonable, and we certainly do wish that teens would talk to their parents about things like that are going on, but we also recognize, I do come from a background of working in domestic violence, and so I do understand that there are a lot of families where it's really not easy to have that communication, and you can't necessarily force that communication. So in 2000, up until 2010, we considered ourselves sort of a progressive state, and then we had a big change in our General Assembly, and I do want to point out, conservatives and liberals, the Republicans and Democrats have sort of chosen in their platforms where they stand on abortion access. That doesn't mean that every Republican, particularly there's lots of Republican women who don't necessarily oppose abortion access, and you will also have Democrats who do oppose abortion access. So I don't think it's really so much along party lines. It has, there's a lot of personal beliefs involved. But in general, we did have a very conservative turn to our General Assembly in 2010 after the election in 2010. And then you started to see a lot of pieces of legislation. It's not that we didn't have to necessarily push back on these restrictions prior to 2010, and we were there doing that. But it just was, there were times when legislation would be introduced that was be these onerous restrictions that could be then held in committee and never come out for a vote. And then that sort of changed in 2010. So you saw a lot more of these restrictions that some people had been waiting to push for a long time, finally coming to the floor and getting voted on. So I do want to give you, Guttmacher Institute has a lot of great data on abortion and reproductive rights and birth control. And in 2011, which is the latest year that they had some data for North Carolina, I do want to just point out that their data was that there are 14.6 abortions per 1,000 women of reproductive age here in North Carolina, which is slightly below the national average of 16.9. And now I do want to also mention that there are people, for example, in North Carolina right now, earlier this year, the clinic in Jacksonville, North Carolina closed, which means that from Fayetteville to the east, there's a clinic in Fayetteville, and then to the east, there's no clinic. There's no way that you can get an abortion in a clinic. The Planned Parenthood in Wilmington does not offer abortion. So you've got some folks who go up to Virginia, some who might, South Carolina doesn't have a lot of good access either. But you do also, these numbers don't necessarily reflect that there are some women from other states, particularly like down there near Charlotte, coming in from South Carolina. There's some abortion clinics in Charlotte. They'll come and get an abortion there. And then some North Carolina women will go out of state. So those numbers, they're reflective of the North Carolina numbers in general, but there are a lot of issues going on with that. And then so in 2011, the General Assembly voted specifically to defund Planned Parenthood. Now, a judge ruled they couldn't do that because somebody literally stood up on the floor and said, we're defunding Planned Parenthood, which, of course, probably constitutionally, you cannot target an organization like that. That was really kind of a slip on that person's part, but that was enough for the judge to say, no, you can't do that defunding. And so, but then in 2011, Planned Parenthood still had state funding, but then they also, in the General Assembly, introduced the Women's Right to Know Act, and this was a lot of abortion restrictions. I mean, for what it's worth, I think that we don't have a lot of depending on what kind of sex ed you get, in North Carolina can be spotty. We don't have a lot of great information on pregnancy and birth control and reproductive health issues. And I am all for people having the information that they need, including about abortion. But this is really very much this paternalistic, well, women just don't know what they're thinking about when they think about abortion. So that's where they introduced the waiting period. It was a 24-hour waiting period. There's a script now that politicians wrote that's pretty appalling, that has to be read by, and it can't just be read by the person seeking the abortion. It has to be read to them by a nurse or a doctor, meaning that you are also paying for that time for somebody to read these restrictions to you, or this counseling to you. And it has biased information in it. It's not medically accurate, but it is something that now patients have to hear prior to the waiting period. You have to hear that, then you have the waiting period, and then you can come in for your procedure. And I will say also that is something that has to be read anytime it's a procedure that is an abortion, and that includes when you are, sometimes the doctor has to finish a miscarriage that was not, miscarriages sometimes don't complete, so you have to go in and have the procedure. They have to read that then as well. And so, and then also there was a forced ultrasound where the doctor had to describe things that the politicians had written that you have to say that this is what they're seeing. And then, and you know, the patient was not allowed to request not to hear that. Now, that was found unconstitutional, so they don't have to do that, but they still have to hear the script. And then if providers don't follow these procedures exactly, they can be sued by the patient or the person who impregnated the patient. I mean, it was just kind of a way of opening up doctors to more liability, and liability that isn't really necessary. It's not about malpractice. It's about sort of having this chilling effect on, and some of that I think, no, I'm not going to speculate. I have some speculation about what some of the things they were trying to do with that, but that's where we are. That was in 2011, the Women's Right to Know Act. And then in 2012, we had a change in our governor, which meant, you know, because the governor prior to Governor McCrory was Governor Bev Perdue, she had vetoed a lot of restrictions, and they didn't necessarily have the votes needed to get through those vetoes. In 2012, that changed. There was really a supermajority of conservative lawmakers who, you know, in their platform said that they're opposed to abortion access, and then you had a governor who wasn't necessarily going to push back on that. So in 2012, they successfully defunded Planned Parenthood in North Carolina, so they don't get any state dollars. So sometimes you will hear people still say that. No, Planned Parenthood in North Carolina does not get any state dollars. And then in 2013, some of you, I don't know, some of you, probably plenty of you are not from North Carolina, and you may not have been here in 2013, but it was a national story when right before the 4th of July, I was at the gym, and I was looking at Twitter, and they said they just introduced this bill with all these restrictions, and nobody is there. Nobody was given any kind of notice except the anti-abortion folks who helped write the bill. But nobody was there to give any kind of testimony against any of these restrictions. And I went over to the General Assembly right from the gym. And it really, like, I had heard, this was a lot of what was going on in Indiana and Texas and other places where this model legislation was being introduced. And that was what was happening in North Carolina right before the 4th of July holiday. We did manage to get like 600 people to show up and protest the next day. But it was called the Motorcycle Vagina Bill. I don't know if that rings a bell. What happened was, I don't want to get too much into legislative details, but there's a point during a long session in North Carolina where if you have introduced a bill, but it has not yet been voted on by either the House or the Senate, it is done for the session, and you can't bring it back. And that was what had happened with this original bill. And so what they did is they had this bill about motorcycle safety, and they just stripped everything out about motorcycle safety, and they put this stuff in there. It's a legislative procedure. It's not a good procedure. Both parties do it. It's just an example of how some things get done there, but that's what happened. That's why it was called the Motorcycle Vagina Bill. And this bill specifically had a whole bunch of stuff in it. It prohibited, you know, at that time we were also getting Obamacare. The ACA was being implemented in the states, and so in this bill it said that you know, any insurance that you buy with your own private money cannot contain abortion coverage. You can't get a rider. So that's all already was prohibited there. It's already prohibited for state employees, and their insurance is prohibited, and Medicaid. And so, and then it also set the trap laws, which I know our other two speakers are going to talk a little more about. It set, you know, wanted to make sure that we establish some trap laws, which are targeted regulation of abortion providers. And trap laws are very specifically laws that only apply to abortion providers, and they typically don't have anything to do with safety or medical issues. And so they'll talk a little bit more about that. And then it also expanded who could refuse to take part in an abortion procedure, and not including, you know, receptionists and janitorial staff, like, could refuse to work for those kind of things. I mean, it's an odd thing to think that somebody who takes a job in an abortion clinic is then going to refuse to do their job because they're opposed to abortions. But that was, you know, they're just always trying to expand, because some people think that maybe that will be a way to sort of bring some abortion clinics down, I guess. And then they also introduced something banning sex selection in abortions, and it was, you know, that's just something that is, when it comes down to it, that's racial profiling. Because what they would always sort of point to was in China and India, where there were issues with preferences for sons, which are cultural issues that really aren't going to be solved necessarily by having sex selection abortion bans. Really, they're solved by addressing the sexism and misogyny that's in your society. But they couldn't really prove that that was happening here in North Carolina, but they went ahead and did it anyway. And some people did call them out on that being racist, which brought up a whole lot of issues with them. But that's in there, and that's like you can be fined for up to $100,000 as a provider if somebody accuses you of doing that. So that was all in the motorcycle vagina bill. And then in 2013, they also they took away the money from Planned Parenthood, which means they were also taking away money that was used for other reproductive health services, as well as the sex ed programs that they were doing at Planned Parenthood. And instead, in 2013, they took $250,000 of taxpayer money and they gave it to crisis pregnancy centers, which some of you may or may not know what they are, but they're basically ministries that want to encourage women or really pressure women to not get abortions. It is one thing to set up a ministry that wants to offer support to someone who's in a crisis, who feels like they're in a crisis during the pregnancy, and they want to maybe talk to somebody who can pray with them. Sometimes they do Bible study. That is all fine. What they do, though, is they tend to present themselves as like an all-options clinic, and then they will like do things like in Charlotte, they have a bus that has an ultrasound on it that they park in front of the abortion clinic, and they do try to, they flagged me down when I was going to the clinic, and they wanted me to get on the bus with them to do an ultrasound. And what they're going to do then is like really be like, do a lot of pressure and guilt and shame to get you from going to your appointment. And sometimes they will present themselves as actually being a part of the abortion clinic, saying like, we'll save you time by doing your ultrasound here. So there's a lot going on with them. And, now they get tax dollars. And I think it's definitely reasonable for us to consider that if they get tax dollars, they just need to be truthful about what they're doing. So that was in 2013. In 2015, where we're at 2015, is that 90% of North Carolina's 100 counties have no abortion provider, and 53% of the women in North Carolina live in those counties. So it may not be a lot to have to travel across the triangle, but sometimes it is. If you don't have good access to good transportation, it can be a lot to be living in Wake County and having to go to Durham County to get your abortion. And if you live, like I said, anywhere east of Fayetteville, it's a fairly long drive as well. And we have currently 8 abortion clinics in North Carolina, and they're clustered in urban areas, and so you've got large parts of the rural parts of the state that don't have an abortion provider, and then we have 4 Planned Parenthoods that provide abortions as well, but they're all clustered in the same area. And so in 2015, we got the Women and Children's Protection Act, and this is where they took the 24-hour waiting period and they made it 72 hours. And North Carolina is one of only 6 states to have the 72-hour waiting period. And then they also created these new reporting requirements. In North Carolina, you can't get an abortion after 20 weeks. And so if you perform an abortion at 16 weeks or above, between 16 and 20, you have to send that ultrasound to the Department of Health and Human Services with the doctor's justification for why that was done. We don't really know who gets those or who is looking at those or what those are for. Except for intimidation. I mean, when they were talking about that bill, somebody said, we think doctors are lying and performing abortions after 20 weeks, which is illegal. And really, there are plenty of doctors who will not perform abortions even close to 20 weeks because they don't want to get into that. And so, for what it's worth, I had somebody call me who was talking about somebody who had a fetal abnormality at 21 weeks and had to go to Georgia for that procedure. And also found out her insurance wouldn't cover it. So, but that's just, I think there's been a lot of discussion since the 3rd presidential debate about late-term abortions, and I hope that some of you have seen some of the stories about who that is impacting, like what it means to really be so far along in your pregnancy that generally is a pregnancy that you were really happy about, and you've got your room, the baby room decorated, and then suddenly you get this really terrible news, and now you've got these really political things, like you couldn't even stay in your state to do this. You had to go. Your doctor had to recommend that you go out of state to do it. So that was all part of the Women's and Children's Protection Act. And they also, I will say, in that act, they put in some provisions to help victims of domestic and sexual assault. And it was really a very political ploy to say, well, if you vote against this, then you must be voting against, domestic and sexual assault victims. What they were trying to, which was ridiculous, because what you're doing is saying that victims of domestic and sexual violence are never the same people who are seeking abortions, and that is not true. I mean, rapes account for 32,000 pregnancies in the United States each year, and also reproductive coercion is a thing, and it definitely, unplanned pregnancies are a lot more likely to happen in abusive relationships because there's a lot of power and control over the woman is allowed to use birth control or not. So so that was just sort of a very political bill that they had done. And then the last thing they did in 2015 was they attempt to criminalize drug use in pregnant women. And Tennessee is currently the only state that has that, where they will, if a pregnant woman is using drugs, they will put her in jail. That did not get very far here. We're concerned it might come back because it's definitely hard for people to be sympathetic to that. But there are a lot, it's an addiction, and we don't necessarily believe that women get pregnant and then decide to start using drugs. It's an addiction, and they're not really going to get the help they need in jail. Like, if we are really concerned about the woman and the fetus, like, there are other ways that we can help that woman safely carry her pregnancy to term beyond putting her in jail. And then in 2015, as I mentioned, in 2013, they gave $250,000 in taxpayer money to crisis pregnancy centers. In 2015, they upped that to $400,000. So that is where we are. I know that's a lot of information, but as you can see, it really was kind of quiet for a long time in North Carolina, and then there was just a lot of stuff, making North Carolina really considered a pretty hostile state for reproductive rights.
Thank you. Thank you very much. So I'll try and put the whole women's health decision in some historical context, and then just briefly explain what the court did in the opinion. So Roe in 1973, as Tara mentioned, declared a federal constitutional right to abortion protected under the liberty of the due process clauses, and the court, speaking generally, subjected restrictions on access to abortion before viability to strict judicial scrutiny, which is ordinarily the most demanding test known to constitutional law. Restrictions on access had to be narrowly tailored to achieve a compelling governmental interest. The conflict over abortion, which was unfolding in legislatures before Roe was decided, increased substantially over the ensuing decade. The Republican Party mobilized around the issue and tried to and succeeded in peeling off many Catholic voters, as well as evangelical Christian voters, but fundamentally Catholics who had traditionally voted Democratic, and it helped produce the Reagan victory in 1980 and his reelection in 1984. 20 years after Roe, in light of quite strenuous, and seemingly endless conflict over abortion, reconsidered its position in the Casey opinion, Planned Parenthood against Casey in 1992. It's a case in which, I don't know how many of you know this, Chief Justice Rehnquist initially wrote a majority opinion overruling Roe. 3 years earlier, Justice Kennedy had joined an opinion by Rehnquist that would have overruled Roe, but Kennedy, after argument, after the initial opinion drafting, had a change of heart, and instead of overruling Roe in 92, the court forged a compromise. It reaffirmed the core of the right to abortion before viability, but it changed the level of scrutiny from strict scrutiny to the undue burden standard. The court declared that governments can regulate abortion throughout pregnancy, both to protect fetal life as well as to protect women's health, but what they may not do is impose an undue burden on access to abortion, and the court defined an undue burden as a restriction and that has the purpose or the effect of imposing a substantial obstacle, placing a substantial obstacle in the path of a pregnant woman who seeks to abort a fetus before fetal viability. And I think it's important to understand what the essence of the Casey Compromise was, and I think the essence can be found in the distinction between prevention and persuasion. Casey allowed governments to take sides in abortion disputes and attempt to persuade a pregnant woman not to have an abortion, but Casey prohibits governments from preventing women from having abortion, from coercing them to give birth and disabling them from making the ultimate decision. In the wake of Casey, we saw more traditional restrictions that were aimed at protecting fetal life, we also saw second-generation restrictions that were responsive to concerns about the anti-abortion movement in America, namely that it was hostile to women. And what you saw was increasingly justifications, restrictions on access that were justified not as protecting unborn life, but as protecting women's health. And these restrictions, which were dubbed trap laws by their critics, targeted regulation of abortion providers, did a variety of things, two of which were at issue in whole women's health. And again, the justification was not that we're trying to protect fetal life, to express respect for the dignity of fetal life, but that we want to protect the health and well-being of women who decide to have an abortion. We want to make sure the context, the setting in which they have an abortion is safe for them. Casey, in reaffirming the core of the right in Roe, spoke not just to fetal protection measures, but also to health-justified restrictions on access to abortion as well. I would bet that most of you didn't read or don't remember reading the portion of Casey that speaks to health-justified regulations of abortion. In case you're wondering, it's at 878 in the U.S. reports. The court said that as with any medical procedure, the state may enact regulations to further the health or safety of a woman seeking an abortion. Unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on the right. And so the court is distinguishing good faith, actual health regulations from unnecessary health regulations. And if you think about it, you could see why the court would be concerned about unnecessary health regulations, because a ban on medically unjustified restrictions on access to abortion plays a crucial anti-circumvention function. The Casey Compromise amounts to nothing if states can simply take a restriction on access, an attempt at prevention, and have it go from being unconstitutional because it's justified as protecting fetal life to becoming constitutional because it's relabeled as protecting women's health. Right? And so that's why I think the Casey court is concerned about these unnecessary health regulations of abortion. We've seen an increasing number of trap laws in recent years, laws that require abortion clinics to be outfitted as mini hospitals, ambulatory surgical centers, which was at issue in whole women's health. And the problem is that the vast majority of clinics can't afford to meet those requirements. We've seen admitting privileges laws, which require doctors who perform abortions to have admitting privileges at local hospitals, and the doctors overwhelmingly can't obtain the admitting privileges. And it's not primarily because of ideological disagreement with abortion, although it is that. It's also because in order to obtain admitting privileges, it has to make financial sense for the hospital. You have to actually admit patients. And the problem is that abortion is so safe relative to other procedures that the doctors can't justify that they're actually going to admit people if they obtain the privileges. There are laws that require abortion providers to give inspectors access to many more patient records than healthcare professionals who perform more complex and risky procedures. There are laws in Texas and Kansas that require scientifically inaccurate warnings that abortion will cause various physical health problems like breast cancer. There are counseling laws in 9 states that require abortion providers to inform women that they're likely to experience various kinds of psychological harm if they obtain abortions, than if they carry their unplanned pregnancies to term, claims that social scientists have repeatedly debunked. And so these laws arise in the wake of Casey, and if you look at the leadership of organizations like Americans United for Life, they're pretty candid about what their objective is, which is to do incrementally and indirectly what Casey prohibits states from doing directly. I can read to you, if you're interested, quotes from the leadership of the organization expressing just that objective. And what the court said in Whole Women's Health, in essence, is cut it out. That's what the 5-justice majority said in Whole Women's Health. It is, make no mistake, the strongest reaffirmation of the constitutional status of the abortion right in the United States since Casey in 1992. And what the court basically held is that it's unconstitutional under the Casey undue burden standard for states to restrict access to abortion in the name of protecting women's health when those restrictions lack medical justification and have the effect of making it more difficult for women to obtain safe reproductive health care. My own view is that the decision is correct under Casey. As I mentioned, that decision prohibits laws that have the purpose or effect of imposing an undue burden, and which, in applying that standard to health regulations, balanced the asserted benefits and burdens of the abortion regulations at issue. Abortion, as I've mentioned, is so safe that complications rarely arise, and yet Texas, notwithstanding the absence of any health justification, required doctors to obtain admitting privileges, required abortion clinics to be outfitted as mini hospitals, and no such requirement is imposed on other medical procedures that are substantially more dangerous. Childbirth has a mortality rate 14 times greater than abortion, and yet Texas allows women to give birth at home in the presence of a midwife without access to a physician. Colonoscopy has a mortality rate 10 times greater. Liposuction has a mortality rate 28 times greater than abortion. And so as Justice Breyer concluded, for the majority, a burden on access that is imposed in the name of protecting women's health is undue when the burden is both severe and bears little or no relation to the actual protection of women's health. Trap laws, I think, are in serious constitutional trouble in the wake of these decisions. This decision, that is, laws that are justified as protecting women's health. The court has said that you've got to look at not just the burden on access, but the medical justification. And the greater the lack of justification, the more a given level of burden is likely to be undue. The court also emphasized that you have to look at not just the effects in a cost-benefit analysis sense, but you have to focus on the lived experience of women who seek to obtain abortions and what the cumulative burden of the restrictions is going to have on their ability to obtain access. Justice Breyer wrote the following: in the face of no threat to women's health, Texas seeks to force women to travel long distances to get abortions in cramped to capacity super facilities. That was not said in the service of upholding the provisions. I also think that many fetal protective abortion restrictions are going to be in serious trouble after this decision, because they are also governed by the Casey test, and they are also, therefore, subject to the same balancing inquiry. Let me stop there in the service of time. Happy to explain why I don't think either side in this litigation was genuinely interested in the health of women who seek abortions in any part of the state of Texas. Indeed, at the very time the state is arguing that it's concerned about women's health, women are dying in the state of Texas in numbers the likes of which we have not seen in a very long time. You have World Health officials concerned that the situation in Texas is akin to war and famine. That's what the female mortality rate looks like now, given all the Planned Parenthood clinics and other clinics that are closing, even the ones that don't provide reproductive health care, that is to say, abortion, because of the lack, the defunding of these institutions and other restrictions. So let me just stop there and turn it over to you, Kate.
Okay, I'm going to try not to repeat what's already been said and use as little time as possible. I want to focus mostly on the motivation question. So most people who are opposed to abortion are opposed to abortion on moral grounds because of the status they give to the fetus and the status that they think all of society should give to the fetus as potential life. So accordingly, before Roe versus Wade, most legislation prohibiting or otherwise restricting abortion was on moral grounds, and without the need to dance around and try to mask that moral grounds. As Professor Siegel said, after Roe versus Wade, and especially Casey, you could no longer have a fetal protecting morality-based justification if there was an undue burden on women. So the focus kind of shifted over to the fighting on the terrain of what was an undue burden. And part of what was gradually more and more of the state offered justifications for abortion restriction came not only to sort of proving that there wasn't an undue burden, partly on the grounds of it was actually going to benefit women. So waiting periods, counseling requirements, parental consent laws, ultrasound law, laws banning abortion advice over the telephone, and so on and so on. All of these were justified however, for whatever reason they were enacted, they were justified when challenged on the grounds that the state had an interest in making sure that the woman's decision was informed. That's what the women's right, Tara mentioned North Carolina legislation was called Women's Right to Know. So it was all cast in terms of women's interests. These were not direct prohibitions against abortion on behalf of fetal survival, but rather prohibitions that slowed down the woman, caused her to think more about her decision. In the case of minors, requiring her to consult with her parents, get information about the physiological state of the fetus, when the fetus feels pains, what body parts are formed, and so on. And most of these regulations, or a lot of them anyway, the lion's share of them have been upheld with little inquiry into what the underlying facts were of that legislation. So basically, it was sufficient that the state could connect kind of logically those statutes with the state's interest in having the woman be well informed. The regulations in whole women's health represent really another generation of this type of regulation. They don't regulate abortion directly, nor do they regulate what the woman has to do before she gets an abortion, wait a certain amount of time, get counseling, and so on, but they're regulating the clinics as a health facility or the doctors in terms of their status with hospitals or whatever. So it's just another kind of another layer of another type of regulation. Arguably for the same purpose of reducing abortions, but kind of cast in a different way, and again, in a way that allows those regulations to be logically connected to the health and welfare of the mother. This type of justification, this woman-centered justification, picked up a lot of steam in the Gonzalez versus Carhart case, which I don't think Neil mentioned. This is a 2007 case, you may be aware of it, that upheld a particular form of medical procedure for late-term abortions. And this case really represented maybe the heyday or the acme or whatever of the woman-protecting rhetoric that was seen in the earlier cases, but really kind of defines, what defines a medical regulation. The heart of that opinion really is Justice Kennedy describing the regret that women feel with abortion, and in particular how regretful they would be if they knew in advance how gruesome and horrific the particular procedure that Congress had prohibited in that case would be. And there were a number of facts that were an issue in that case, and Justice Kennedy, in the writing for the majority of the court, basically deferred to the facts that Congress had presented or that were presented in defense of the statute, even though the weight of the medical opinion went the other way. So there were questions about, for example, whether, or maybe the most important factual dispute, was whether this procedure that was being prohibited was really the best procedure health-wise for women. And people defending the statute said it wasn't, and the doctors were saying, yes, it is. It is the best procedure for a particular set of circumstances in late-term abortions. Again, Justice Kennedy accepts the facts offered by the defenders of the statute, and that was that. So this case emboldened state legislatures to move more and more in the direction of laws that could be defended, explained in terms of their benefit to women, even though that may not have been, and probably wasn't the purpose that they were, certainly wasn't the purpose for which they were enacted. Now, in the whole women's health case, Justice Breyer, who's writing for the court, does not directly accuse Texas of bad faith in having an impermissible purpose, either in having an impermissible purpose or in having claiming a purpose that it did not actually have. But it really amounts to the same thing in holding that the district court was right to find no factual basis for the purported rationale offered by Texas. So, in other words, instead of deferring to the facts of the legislature, Justice Breyer cites language in Carhart, language which Carhart really didn't follow itself, but there was language in Carhart that said that a court had an independent constitutional duty to review factual findings, and use that language then to approach the matter in a whole different way in terms of examining whether or not there was an actual factual basis for Texas's rules. So that really, to me, is the big significance of this case, is in the willingness to not defer to what the legislature is saying it's doing, but rather looking to see if there's a plausible factual foundation, and the district court had found there wasn't, and the majority of the court agrees. Okay, so impact of the case. So this case means that legislatures aren't going to be able to get by the undue burden test simply by asserting benefits to women's health. So it can be logical, but if it doesn't have a factual basis, it's not going to work after whole women's health. Now, with this indirect avenue shut down, it's really not clear. We'll have to see what develops. It's really not clear whether legislatures are going to be in a better position by resorting to women-centered arguments than not. I mean, they're going to still do it. It's relevant to the undue burden test. But in the long run, one could argue that the anti-abortion movement would do better by going back to the moral arguments on which they began, because that's in building the public support for that position. It seems like legally this avenue of getting incremental anti-abortion regulations through has been really substantially undercut by this decision. What about abortion regulations that have been previously upheld? Okay, the counseling requirements, the waiting periods. I don't know, we may talk about whether or not this distinction that Professor Siegel suggests between persuasion and coercion, where that stands after the Hellerstedt case. I think there are a lot of, most 35 states now have mandatory counseling laws, most of which specify what information a woman must be given, and it in a lot of states it's not accurate. It's not accurate, not scientifically accurate, or from a health basis, accurate information. These ultrasound rules that have been referred to, mandatory waiting periods, parental consent laws. Parental consent laws work under a factual assumption, which on the right record might be shown to not have a very sound factual basis. So are these rules, most of which have been upheld, except in those states that have found them unconstitutional under their own state constitutions, have they been upheld under the federal constitution following the Supreme Court jurisprudence? Does whole women's health now put these in question? I wonder about the Hyde Amendment. So every year Congress passes laws saying you can't use federal funds to finance abortion. We use federal funds to finance many other to subsidize many other medical procedures. I mean, the whole Medicaid system is using federal funds to finance medical procedures for low-income people. So is this way of treating the medical procedure of abortion differently from other medical procedures itself going to run afoul of how women's health is interpreted? Probably not right away, probably not until there's another Supreme Court justice appointed by a Democratic president, just as a political reality. But I think the logic of Hellerstedt could make us go back and re-look at and perhaps potentially re-challenge some of the regulations that have been upheld. The last thing I want to mention, most of you who have studied who have had constitutional law and studied the abortion cases are aware of the tension between whether we should look at the abortion right as primarily, as it has been, a substantive due process, privacy/autonomy grounded right, versus whether or not we should look at abortion as a matter of women's equality. Supreme Court, again, clearly has come down on the side. Roe versus Wade started with substantive due process. We've stayed with substantive due process, although there have been mentions by some liberal Supreme Court justices of the equality interest as well. With Whole Woman's Health, I see this case as really merging the legal grounding in substantive due process with a fuller understanding of the equality dimension of reproductive rights. Trying to short circuit this, but I don't think I can avoid just in 2 sentences saying what the equality argument would be. One is that abortion laws are based on stereotypes, normative stereotypes about a woman's proper role as a child rearer. You can spin all that out for yourselves. Or secondly, that women's opportunities in society, women's opportunities for citizenship, for employment, and so on and so forth, are so affected by, are really determined by their ability to control their own reproductive lives. So those are the equality arguments. Without mentioning the word equality, one could read Whole Woman's Health as a decision that is, by looking much more carefully at the factual suppositions or claims of legislatures and look at them and taking more seriously the burdens that those impose on women, that we could see the beginnings of a stronger equality subtext in these decisions. And finally, I leave you with the thought that it may be that the more that we see these cases as cases of gender subordination rather than matters of privacy and autonomy, we may begin to be suspicious, not just that when a law is justified because it helps women, we should be suspicious that that's really a cover for a fetal, a more moral-based, Tara said, ideological fetal protection motivation. The more we see reproductive rights in terms of women's subordination, the more we may be suspicious even that fetal protection justifications are actually a cover for a more ideological kind of anti-woman or traditional women's role sort of motivation. And after Hellerstedt, that won't be good news for the anti-abortion movement.
All right, thank you, Kate. We have about 6 or 7 minutes. We have some time for Q&A. Questions? Yes, Sarah.
So I know that the FDA has a lot of rules and laws about how you can present medication. So, you can't, companies that make prescription drugs can't market them for purposes that aren't FDA approved. So why is it that these crisis centers can have such misleading, marketing about what they do and what they are?
I mean, I don't know legally. I mean, one guess I would have is that a lot of people just don't know what they're doing. I mean, I think they fly under the radar for a lot of things, but there's probably...
So there were those Fourth Circuit decisions, which I'm not actually prepared to talk about, right? But I know that the counter argument was the First Amendment. They claimed the city of Richmond, or was it Richmond?
Right, they're not prescribing medication, right? So you're talking about FDA regulations of off-label use?
Yeah, but
because that also happens quite frequently, so I'm not sure about the premise.
There was a decision that said, ordinance that said you can't misrepresent, you can't represent, and in fact, they ordered the women's pregnancy centers to post certain signs, including they had to tell people that this wasn't actually an abortion providing service, and they had to tell them where to go if they really wanted an abortion, something like that. And part of that was upheld, and part of it was not. And I don't remember which. I'm not familiar enough with the First Amendment aspects of this to know this very well. But that was the claim that was made, that these centers should be able to present themselves how they want.
Right, like the First Amendment, my understanding when looking at this was that, First Amendment also means you can't compel somebody to say something that they don't want to say, like by compelling them to say that we don't refer to abortions. Now, California did just pass a state law called a Truth in Advertising law, which is something that can be done, and that's where, and they just passed that a couple months ago about, like, if you're advertising services, you just need to be truthful about what the services are. Now, I'm sure that there will be legal challenges to that in California. But that's what at least I've seen with those kind of challenges.
Yes.
You all did a really great job of sort of drawing out the history of the different attacks on women's health and women's reproductive rights. And I'm wondering, after Hellerstedt, Professor Bartlett, you had started to allude to this a little bit, but where can we expect the next attacks to come from? So, first we had we're doing this to promote women and to make women safer, and then we're gonna make the doctors more credible and make sure that we're protecting doctors. So where can we expect the next line of attacks to come from?
You mean lines of attack from the anti-abortion movement? Yeah. I think you're going to see, we've got plenty of fetal protective laws on the books. I think we have plenty of women protective laws on the books. I think we have some that are justified as both. And so I think I can't think of a new, I think there's a question for the anti-abortion movement, which is a they, not an it, right? There are different groups who disagree about incremental moves versus we can't wait forever, as well as which kinds of laws they promote and which kinds of justifications they articulate. But I suspect there's a lot of waiting to see what happens with the election and the Supreme Court, as well as seeing how lower federal courts interpret whole women's health. So I can't think of a new category, right, of sort of women protective, fetal protective, both. I'm not sure what the sort of the neither category would look like.
So I think there are going to be, if you can believe more, there've already been so much, but there are going to be more and more attacks on courts and on the court system. And I think, again, and calls for overturning Roe versus Wade or Casey or whole women's health. And I think that they're going to be just dead-centered relying on the moral arguments, because those are the ones that actually have an audience, I think, more than, you're not going to sell the public on abortion laws who don't believe in the moral aspect of it just on the basis of women's health. It's Justice Breyer said, basically laughable to think that these are actually in women's interests. So,
right, but I'm not sure that the reasons why the anti-abortion movement has gone to women's health arguments are going to go away, which is decades of political learning that if you frame the issue as unborn life versus women, right, they're going to lose more often than not, at least in general, and particularly at the national level. And so now the argument is we're not anti-woman, we're pro-woman. It's in fact the fetus and the pregnant woman on the same side versus whom? Versus greedy abortionists, right, who want to perform procedures that women are not fully aware of. Right, it's the abortion industry that makes money off of women, and I think so I'm less confident that we're just going to go back to the moral argument and say it's really about unborn life, it's not about women. I think you're still going to see arguments that it's both. And what I find interesting and actually helpful as someone who's developing equality arguments, and I would say it's not just individual justices, it's the court itself in Casey several times protects equality values under substantive due process, just like the court has done with respect to gay rights in Lawrence, in Windsor, and Obergefell. But what I think the argument of those who advocate on behalf of reproductive rights has always been it's not just about unborn life. It's about that, right? There is genuine concern about that, but it's about women too. It's about their roles. It's about their nature. It's about their decisional competence. And what you see implicitly and sometimes unwittingly, an acknowledgement on the part of the anti-abortion movement that that's right. Because if women really were being women and knew what they were doing, there's no way they would have an abortion. And so if they're doing it, it has to be because they're not fully informed, because the doctor is twisting their arms, because someone else is trying to make money. And so these women protective arguments that extend not just to is the facility safe, is the doctor fully trained, but this post-abortion syndrome, this idea of post-abortion regret, I think you're seeing the argument that it's about women too. It's not just about fetal life, I think being expressly joined. Last point I'll make, because I can't help myself. Kate, you had said that the court in Gonzalez against Carhart talked the talk of an independent constitutional duty to review facts, but in fact they walked the walk of deference. And the court in Carhart expressly rejected two findings of fact by Congress. First, that this procedure, the banned procedure, so-called partial birth abortion, is never taught in medical schools. And the court rejected that as factually false. And second, that there's a consensus of medical opinion that the procedure is never safest for women. And the court expressly rejected that. And the reason I mention that is because the Fifth Circuit in Whole Women's Health said that in our circuit, it's rational basis review. We are required to defer to the findings of facts by the legislature. Don't tell us this is medically unjustified. And so that flies into the teeth, not just of Casey, but in my view of Gonzalez against Carhart as well. And I think it speaks to, when you ask, how did this case on such a flimsy justification get all the way to the Supreme Court? I think it tells you about what state government lawyers and federal court judges are prepared to do in the name of resisting the court's abortion jurisprudence. It's not just like any other right or any other litigation matter that the federal courts routinely deal with. And now we are over time, but I will stick around. I don't know if others can stick around if you do have questions.